Today I had a client with a very difficult set of facts. She was under 21. She blew about 6 times legal limit, a little more than 6 times legal limit. Legal limit for an under 21 driver is 0.02, and she blew around a 0.13. Very difficult set of facts for sure. But we were able to do some things in the case that really set the case up to get a great result for her ultimately today. And I want to talk to you a little bit about how it is that played out, why it played out that way, because it really illustrates to you why it is that having a lawyer who understands the issues in the cases and who understands really dialed into paying attention in terms of the way that the law is changing right now. And there are dramatic changes in DUI law that have occurred and will occur in the next couple of years. That if you have a lawyer who's really dialed into the current state of the law and where it is that the law is going, you would have been able to leverage some things in this case and set it up for a really good resolution. But if you had a lawyer who's not really paying attention to things, she never would have gotten this result. So this is what happened. She's arrested in a small jurisdiction. Her case is put into municipal court. Municipal court prosecutor rightfully says, based on the current state of the law, I'm sorry, I'm not giving you a reduction. She's 6 times the legal limit. Who would reduce that case? Sort of laughs at me whenever I'm asking for a reduction on it. What she didn't realize was that there's a case that was pending before the Georgia Supreme Court, Elliott versus State, which would subsequently change whether or not the state could tell you whether or not a refusal of a breath test could be used against you at trial. My client was told whenever she was arrested for DUI that a refusal to submit to the breath test would in fact be admissible against her. And that was part of the information that she relied upon in making her decision as to whether or not to submit to the breath test. That made a huge difference. And so what I did was, I was in a municipality, in a municipal court. I transferred the case from municipal court to state court. I had a very long delay in between that time period. In that time period, Elliott versus State was decided. So whenever I went in for a motion hearing today, I was able to talk to the prosecutor and say, look, here's the deal. We had a breath test that was submitted to under the former implied consent advisement. She was told improperly that a refusal could be used against her. We believe that that will affect the admissibility of the breath test. He looked at it, said, you're probably right about this. I'm going to agree to it, and I'm going to reduce the case to reckless driving. She's now over the age of 21. So she does not suffer a license suspension. She was able to resolve the case to a reckless driving without a DUI on the record, without a license suspension. So that was just because I knew what was pending. Now, if it didn't go our way, it didn't go our way, but it wasn't going to get any worse than it was in municipal court. But at the end of the day, we set the case up because we knew what the issues were that were coming down the pike, and ultimately able to get a really good resolution for her. If you have any questions about your case, how it is that we might be able to help you, feel free to call me. My name is Ben Sessions. My phone number is 470-225-7710. Again, 470-225-7710. Thank you.